It's not a court of law. What you're doing is not law. You don't know the law. Show me. I said, show me where you have the right to waive my right to final arrest. Show me what the Constitution says. Show me. Show me. You cannot show me. You cannot show me. You cannot show me because you don't know the law. You can't show me.
May have certain vested interests who want to accuse Nnamdi Kanu of being rude in the court of law. But Nnamdi Kanu was clearly pointing to the judge, the presiding judge, to adhere to the provisions of the Constitution, which empowers him in the first instance to be a judge. There is a law. Without a law, there is not a judge. So judges are not meant to be biased, just as we have seen in the course of reviewing the entire process. Nnamdi Kanu put it on the judge. You are not the prosecuting counsel. You can't be doing their own job for them as if you are aligning with them. Nnamdi Kanu pointed out that you should be a judge and not being, of course, biased or being prejudicial in your position as a judge. He pointed out that, and should that be considered as being rude, when Nnamdi Kanu was denied the right to tender his final written address, just as the prosecuting counsel did. In the court of law, both parties are allowed to present their final written address, which is not an optional or a privilege. It is their right to tender their final written address before the judge. Well, after considerations, we eventually, based on the both parties' arguments and submissions, and based on the preponderancy of the evidence before him, and how the prosecuting counsels were able to prove their case beyond any reasonable doubt, we now also weigh the options of the defending counsels, how they were able to prove their level of innocency. Then thereafter, the judge will be an unbiased judge based on the provisions of the law. Within the content and the context of the law, we make an informed position by dispensing justice. And justice may not have been said to have been dispensed or delivered, not except it is being perceived to have been delivered. So all this case in Nnamdi Kanu deal was not observed. There were no preponderancy of evidence tendered. There were no defense by the prosecuting counsels over the allegations. Meanwhile, the allegations tendered were not criminal evidence. Saying that Nnamdi Kanu was found with a microphone and the rest of them, he insulted Buhari and the rest of them. Is it a criminal offense? It's a civil offense. If you say Nnamdi Kanu insulted Buhari and the rest of them, called Nigeria, is criminal, is a civil offense. If you are insulted, there are provisions of the law that protect you. You can go to court and seek for redress. It's not a criminal offense. It's only in Sharia law. The adoption of Sharia was what was invariably enacted to try Nnamdi Kanu. It's only in the criminal code of Sharia law is being considered as a blasphemy when you insult an Hausa, a Muslim person by a Christian. It's being considered as a blasphemy. And that could be punishable under the law. That is just the case. What is the identity of the lead counsel of the prosecuting counsel? Who is he in person? What is his religion? What is his background? When you fact check his antecedents and the rest of them, you know already who he represents, and the reason why he was pushing for death penalty. On what basis? On the basis that there were preponderances of evidence, or he had been able to prove his case beyond reasonable doubt, and on the part of Omotosho, there was justice and fairness established. Nnamdi can argued, just as you can see in the video. He said, prove to me if there is any written law that gives you the rights, even as a judge, you don't have the right to usurp my rights and privileges. That is what he's saying, and that I support 100%.
No, leave it. I said leave it. It's a court of law. I'm under trial. I'm under trial and I have to speak. I'm under trial and I have to speak. Listen to me, please. I'm under trial. I'm under trial. I'm under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. I'm asking a very simple question. No. Wait. Please. Look, this is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. Hold on. I said hold on. This is not a court of law. It's not a court of law. What you're doing is not law. You don't know the law. Show me. I said show me where you have the right to waive my right to final arrest. Show me what the Constitution says. Show me. Show me. You cannot show me. You cannot show me. You cannot show me because you don't know the law. You can't show me. Wait, hold on. Don't touch me. Don't you dare touch me.
The fact you are a judge does not give you the arbitrary right to truncate, overturn the course of justice without recourse to the provision of the Constitution, the law, that even empower you in the first place. You can't be raping the provision of the Constitution. So when he said, which law gave you the right to waive my final written address, Omotosho was thrown off balance. He couldn't answer that because he already knew he was contravening the position of the law. That the accused, the prosecuting or defending counsel has the right to tender their final written address. Why do you admit the prosecuting counsel suggesting a death penalty for Nnamdi Kanu? You also do not allow the defending counsel, Nnamdi Kanu, the defendant, to tender his final written address. That could be clearly seen, even without Nnamdi Kanu saying it, as bias. Omotosho has been greatly influenced by certain vested interest because at that particular time, there is no sense of impartiality. He is biased and nothing short of that. That is nothing but the truth. Now, let's listen to the conversation of one of the lawyers being interviewed in the Rise TV program, and you see what he has to say regarding this.
Those lawyers. I also do not know why he decided to defend himself. But what is those are now in the realm of history or in the realm of the past. What now bothers many Nigerians was what happened on November 20th, the day he was sentenced, and the day he was convicted and eventually sentenced. And the whole issue surrounding the trial, the whole issue surrounding the conviction and the sentencing, the attitude of the court itself, whether the court followed the law or whether the court followed personal opinion of the jurists, or whether the court, in some people's opinion, acted on a script to ensure that Nnamdi Kanu is taken off the streets, in a manner of speaking. Whether Nnamdi Kanu defended himself or not, what to many people is more critical and more important is the attitude of the judge. And the justice of the matter. Don't forget that in criminal adjudication, one can only be convicted when there is preponderance of evidence, one. Two, and when the prosecution is able to prove the case beyond all reasonable doubt. We are not saying all iota of doubt, but at least all reasonable doubt. And that justice must not only be done, but to be seen, manifestly be seen as having been done. The generality of the public of Nigeria and even the international community do not believe that justice was done in Nnamdi Kanu's case. Don't forget that the issue of treason is a political decision by the state, because treason is an offense against the state. It has been brought to become an offense against humanity. And that is why there is an international convention against treason. And it was to be able to bring it to the level of, to align Nigeria's act with that of the rest of the world, following the UN convention, that brought to the repeal of Nigeria's 2011-2012 terrorism prevention Act, and reenacted in 2022 with implementation in 2023 of Terrorism Prevention and Prohibition Act. Now, the whole issue about Nnamdi Kanu's matter beggars a lot of questions and defeats a lot of logic, because a lot of people, even Nnamdi Kanu himself had continued to say it, even rambunctiously in court, that they should show him the law with which he's being tried. Because by the time many people didn't understand, because all the people who were not privy to the charges and people who were not privy to the goings on in court were at a loss as to why would a man be charged for an offense that is not known to law in a criminal trial. Because a Nigerian statute book says that one cannot be tried for a law of an offense not codified and known to law. And then
under the principle of fair
hearing,
sections 35 and 36.
Absolutely. And there is nothing like retrogressive action in law when it comes to criminal action. Yeah. We are not a military regime. Now,
but Nnamdi Kanu was charged under the old law.
Under the old law.
Terrorism.
He was charged under the 2020.
No, not under 2022. Under the older law of 2013.
2013, not 2022, 2013. That was repealed.
The old law.
The old law that was repealed in 2022.
Yeah, but so the new law will not take effect. That's why Chief Awomolo is saying, he's saying that the punishment is death penalty. He was quoting the old law, and that the accused person was charged under the old law. The
accused person was charged under the old law. Don't forget that that charge under the old law got extinguished in October 2022. When
but the law, you yourself just said it, cannot have retroactive effect.
We cannot have retroactive effect.
Those are issues they will resolve at the level of appeal.
No. There is one major issue that is even on the open. Okay. Because in the first instance, don't forget that Nnamdi Kanu had earlier been acquitted by the Federal High Court before the federal government went to Court of Appeal. And every moment an accused is acquitted, discharged and acquitted, he goes home from the court. He can only go back to the prison or to wherever he was detained to collect his personal items. If he doesn't want, he can abandon them there. If he doesn't want, he can go from there to his house. If he doesn't want, because at the end of the day, the federal government refused to release him. So at that point of that discharge and acquittal in October of 2022, the court became functus officio. So you can no longer hold on that old law. But by the time you saw the judgment from the Omotosho's court, it was referring to the 2013 charge. So that became a very, very strong issue against that judgment and against the entire procedure. Okay. There are so many other issues which time may not allow us to explain.
These are issues that can be worked out when the matter goes to the Court of Appeal. Aloy Ejimako has already said they will go on appeal. Yes, and that by Monday, tomorrow, they are going to file.
He has a whole 90 days. We think we to do so. So he can do that
to notice that Justice Omotosho even said, he was tampering justice with mercy. He was not applying the full teeth of the law. However, what do you think is the way forward? And don't you think that the matter was even complicated by the conduct of the accused person who discharged his own counsel. I mentioned the very senior lawyers who know the territory. Now, in this same case, what's his name now? Ozekome, SAN, was involved. Kanu Agabi, SAN. Paul Erokoro, SAN. Ikpeazu, SAN. These are people who know the law, the in and out of it, who could have provided a different kind of pathway and who could have handled the matter. But we had the accused person abusing the presiding judge, and you said, oh, the presiding judge is a problem. What do you expect his lordship to have done in a situation whereby the accused person took over the proceedings of the court and questioned his integrity, questioned his... So what the judge did eventually in the 144-page judgment that I have seen is that he just applied the law. Simply.
Dr. Albert, you may say so, the judge may claim so, but the judge committed what majority of the people describe as a travesty of justice, and I tell you why.
No, he's
not a mob opinion because there are the facts are there. The judge jumped into the arena. The judge even usurped the office of the executive.
How?
I'll tell you why. It does not lie in the purview of the court to decide where a convict will be kept. The very moment you decide, you give in your judgment, you become functus officio. It is the duty of the executive to determine.
Which means that the matter has ended.
Yeah, the matter has ended. It's the duty of the for the judge to say
he has to be,
for the judge to say he has to be kept in a certain form of confinement. He's jumping into the arena. He's overreaching his office.
Was it the judge that said he must be taken to Sokoto?
No. The judge said so, and possibly for them to have taken him to Sokoto, they may be obeying again the order of the court, which of course is an illegal order because he has become functus officio.
No,
it is not the
duty. Sokoto prison.
It is not the duty
in that judgment.
It is not the duty of.
No, is it stated in the judgment?
No, Dr. Abeti, it's not the duty of the judge to say where he will be kept.
No, is it in the judgment?
No, it's not in the judgment.
Have you read it?
No, but he said so in the judgment that he
said it should be taken to Sokoto.
He didn't say Sokoto. He said in a special confinement. He said so. So, and people were asking, would he be taken to Robben Island in South Africa or Guantanamo Bay in Rhode Island in America, since they wanted him to be completely out of circulation? The judge, in his wisdom, may be thinking that keeping him in an environment where people can have access to him, that people will be coming to visit him, and of course people will be going to visit him. And now the government are now throwing him to Sokoto. What is the basis for throwing him to Sokoto? That is one. But leave that for the executive to answer. But you can query the judge for making such statement because it does not lie in his purview. Again, the injustice done against Nnamdi Kanu
was that part of the ratio or part of
it was part of the angst you mentioned that he insulted the judge.
No, I didn't say
no, he said that he insulted the judge in the open court, the presiding judge, and I now ask if anybody misconducts himself in the court, is it not contempt?
No,
contempt in the face of the court.
That judgment
so it cannot come in any way close to issue of terrorism. If the judge felt he was insulted,
whatever the judge may have said will be
the same way is good. The same way President Muhammad Buhari now converted ordinary law of thought to a criminal offense. Nnamdi Kanu insulted Buhari. Yes, it's open. He called him all sorts of names. He has the reasons for calling him all sorts of names. We criticize such calling of names because he was our president. But we have a law that says if I insult you, Dr. Abati, you take me to court. It's a civil offense. It can't be a crime that he insulted the president and now the president now turned it to become terrorism. Now, another issue that's very important, another issue that still keeps hanging on is if you look at all the counts, the 7 counts, a lot of them will be talking about his broadcasts. Almost about 5 of the charges talk about his broadcasts. And that is why his lawyer said, how has mere puffy, word of mouth act amount to terrorism. You know that when you are talking about criminal issues, you are talking about the actus reus and the mens rea, the reasons and the action. If there was
mind to commit
the mind to
the
commit,
act.
and then the act itself, committal of that act. Where is the committal of the act, and where is the mind to commit the act? What he did was he insulted the authorities.
No,
because he possibly felt that he was not getting what he expected from the system. So these are all the issues that will come on appeal at the end of the day.
Don't let us reopen the case. All these elementary things about criminal law, let's put them aside.
Yes.
The matter has already been determined now at this stage. What is the way forward? What do you recommend?
No, but first,
as counsel?
No, it's very simple.
Were you part of?
No, I was not part of the legal team.
So, what do you recommend?
No, it's very simple. They will go on appeal.
Yeah.
And they have to go on appeal timeously because our law
by
says,
Monday.
Our law says you have 90 days to appeal. But the legal team is up to the task, and they said they are not going to waste any time. But another thing that is important is that now that the written judgment is out, they get certified to a copy of the judgment and they begin to prepare sift through it, bring out all the grounds of appeal, and then go ahead and file the appeal. And that's all. That is the only way forward. And the next way forward is to appeal to Ndibo to take it easy, that this injustice cannot stand. So there's no need trying to get agitated. There's no need trying to resort to self-help. There's no need trying to injure ourselves or injure the people, all in the name of getting angry. Because the law, yes, is an ass, but the same law will be utilized to right the wrongs that have been done against Nnamdi Kanu. I say this advisedly and without any fear of equivocation, that the federal government of Nigeria has not handled Nnamdi Kanu's matter in a judicial.
So what do you advise the Nigerian government?
The Nigerian government, if I am to advise the government, this time around, the buck now stops on the table of the CNC. CNC has now, when he pardoned some criminals and Nigerians raised their voices, and people said, "Oh, why are you not pardoning Nnamdi Kanu?" The handlers of the federal government of the president said the matter is still in court. Today, the court has discharged the matter. Now the executive can now take over and apply the prerogative of mercy. It is completely at the discretion of Mr. President. And if I'm to advise him, I'll ask him to do so and calm frayed nerves so that we will begin to limit the challenges of insecurity we have in Nigeria. It is mounting all around the country. Let us not add to the problems. It's like pouring fuel into a raging fire.
So you cannot understand that the judgment was greatly influenced. There was no justice, that's transparency of justice, of course, and the processes was not fair, has been expressed by its majority, even outside the shores of this country, Nigeria. Well, that is not a dead end, as the defense counsel Thomas Nnamdi Kanu has filed appeal, and definitely such a runner's verdict will be upturned or set aside. As a matter of fact, as I rightly said, that there's been a rigorous litigation, and a verdict was given, not by a high court. Previously, a high court, out of the 15 count charges, struck out about 7 or 8, and eventually, when it gets to the appeal struck out all the count charges left. But the case of Justice Omotosho, no charges was set aside. And all the count charges were just mainly based on hearsay. You made a broadcast, you made this, you made this. It made presumptions. And you want to criminalize an innocent man, a freedom fighter, based on the frivolities and fabrications that was tendered. You never reviewed that, no investigation was carried out, and the rest of them. So indeed, the defendant counsels has the right to appeal, and eventually will definitely upturn whatever judgment given by James Omotosho. The appeal court has a verdict, a substantive verdict over the case of Nnamdi Kanu, discharged and acquitted him. Sadly, Omotosho denying the evidence of the extraordinary rendition of Nnamdi Kanu. You can imagine the extent he went to deny the realities, using a repealed law to try a criminal matter or alleged criminal matter. Wow, that is quite interesting. Of course, it will be a subject of discourse and a phenomenon that will be discussed beyond the courtroom. And Omotosho suddenly will not be forgotten in the history when justice is discussed, when brutal injustice and conspiracy to criminalize a freedom fighter, a man who has not taken any arms against the government of Nigeria, and there was no evidence of such. The reason why the appeal court on the 13th of October 2022 dismissed, discharged, and acquitted Nnamdi Kanu and ordered there is no other court within the Nigerian legal system that has the jurisdiction, the legal right to try the leader of the indigenous people of Biafra on the basis of his extraordinary rendition, which violate every other right of Nigeria to try him. But in a Omotosho case, he denied the two realities staring at us. Well, only time will prove him wrong, and posterity will hold this definitely against him, because people are angry over this perceived injustice, and it's rather unfortunate that he decided to have been used for whatever case. Well, as the case gets to the appeal, let it be sorted out there, because there are erroneous foundations that were laid, which is in contradiction to the provisions of the Constitution and definitely the Constitution. The laws we've interpreted. How could you base a criminal case on a repealed law? Once a law is dead, it is dead and ceases from any correspondence, legal correspondence, and the rest of them. It is quite interesting. And a moment to watch. And the next thing is that the safety of Nnamdi Kanu is in the hands of Tinubu administration. As the terrorists are bragging over the adoptions of girls, secondary schools are collapsing and shutting down, just as Bauchi governor have declared state of emergency, shutting down all the entire secondary, primary, and tertiary institutions as a result of increasing escalations of adoptions and the rest of them. Well, that could be to the gain and achievement of the Boko Haram, because their original intention is to shut down everything that has to do with Western education. So if the incessant adoption will force the schools to shut down, they will be celebrating that to some greater extent they have achieved their intentions, and that is sad that a governor who once supported, promoted the proliferation of arms, supporting and defending Fulanis of carrying AK-lettered weapons, today is shutting down the schools for the very reason he never saw reasons to disagree with. It's rather unfortunate today. Well, let's continue to watch as things unfold. If you're watching us for the first time, don't forget to like, share, and subscribe to this channel for more political updates and discourse. Here you get information, in-depth analysis of events, unbiased reportage of events. Keeping it real has been a commitment. And to this end, we come to the end of today's episode section. Kindly let us know what you feel. Of course, via the comment section, you have the right to express yourself in the comment section, but make sure you give us a thumbs up as you do that. Share this video. Let it get to other people who needed to listen, to your friends and families who needed to get the unbiased reportage of events. Keeping it real. Here is Chigos Debo. Bye. See you next in my next edition.